Following the Norman invasion of England in 1066, a system of centralised administration of justice was established, whereby judges went on circuit throughout the realm dispensing justice in accordance with the wishes of the king. This system attempted to avoid local lawmaking and in turn was aimed at strengthening the power of the king. In this way, the common law developed. However, the term common law has more than one meaning. It's also used to distinguish judge-made law from statute law. The former originates in the courts, while the latter is a product of the legislature's lawmaking power. Litigants suffer a range of disadvantages when attempting to bring a suit or action at common law. They had to bring their actions within one of the pre-existing suits. If one did not exist, the litigant would be without a remedy. Many powerful defendants could use their resources to pervert the course of justice, and in some areas, the common law was simply not effective. Judges' decisions were ignored. In addition, the range of available remedies at common law was limited. By far the most popular remedy was damages. However, this was ineffective in many situations, for example where the plaintiff sought to have the defendant restrained from doing an unlawful act. Therefore, it is not surprising that there was great dissatisfaction with the common law courts. As a result, the Lord Chancellor, the holder of the King's conscience, began to accept petitions from individual litigants from circa 1150. After a time, the procedure for hearing petitions developed and was formalised to some degree, leading to the creation of courts of equity or chancery. In this way, litigants could avoid the confines of the writ system. In their infancy, courts exercising equitable jurisdiction introduced the rights of parties to be witnesses in their own case and the right of a party to subpoena a witness. Furthermore, the courts of equity developed the rule against perpetuities, which continues to play an important role in property and trust law. Finally, the courts of equity introduced a whole new range of remedies for plaintiffs, such as specific performance, rescission, and the injunction. And most importantly of all, they recognised the use or trust. However, by the middle of the 18th century, the common law judges were fiercely resisting the encroachment of equitable jurisdiction. It was becoming increasingly difficult to administer two systems of justice within the same legal regime. The main reason for this incompatibility was that while the early chancellors in theory acted on a number of settled principles in granting or refusing relief, there was little uniformity in the judgments handed down, and the types of remedies varied from one chancellor to the next. This lack of consistency and principle in lawmaking opened the courts of equity to the charge that equity varied like the chancellor's foot. However, the chancery courts moved swiftly to change their ways. A change echoed in the words of Lord Eldon in G. and Pritchard, where he said, "Nothing would inflict on me greater pain in quitting this place than the recollection that I had done anything to justify the reproach that the equity of this court varies like the chancellor's foot." It was not merely the lack of uniformity in adjudication which proved to be problematic. Many jurists believed the existence of two distinct legal systems to be anachronistic and unworkable. A special commission was established in 1850, and following its report, the 1854 Common Law Procedure Act was passed, thereby allowing common law judges the power to grant equitable remedies, such as the injunction. Then, in 1858, the Chancery Amendment Act, otherwise known as Lord Cairns Act, was passed. This act conferred upon chancery judges the power to award damages in addition to, or instead of, the pre-existing equitable remedies. Finally, in 1877, the Judicature Ireland Act was passed. This statute amalgamated the two systems and provided that the principles of both common law and equity were to be applied by a judge hearing a particular case. Furthermore, Section 28 provided that, in cases of conflict between the principles of equity and the common law, equity should prevail. The fusion of law and equity. Academic and judicial debate continues to rage around the question of whether the fusion effected by the Judicature Act was merely procedural or also substantive in nature. Keane notes that the opinion of the House of Lords and United Scientific Holdings and Burnley Borough Council that the complete fusion of law and equity for which Mansfield and Blackstone yearned has taken place since the Judicature Act has attracted severe judicial criticism. As far back as 1880, Lord Jessel, in Walsh and Lonsdale, stated, "It was not any fusion or anything of the kind. It was the vesting in one tribunal the administration of law and equity in every cause, action or dispute which could come before that tribunal." In this context, substantive fusion suggests that, following the enactment of the Judicature Act, legal rights have been modified by equitable principles and equitable interests have been affected by the law. On the other hand, the proponents of procedural fusion argue that legal rights remain legal rights and equitable rights remain equitable rights, though administered in the same court. The Irish Supreme Court decision in Hines versus Independent Newspapers supports the substantive fusion approach adopted by the House of Lords in United Scientific Holdings. However, both cases concern the same point of landlord and tenant law, whether time was of the essence in relation to a rent review clause. Both courts held it was not necessary to rely on the fusion of law and equity to support their conclusion. Indeed, Keane advises caution against adopting the Hines decision as conclusive evidence of the fusion of law and equity. He states, "The distinction between the two systems of law rests on solid foundations and remains part of our law until the Oireachtas, or the only legal tribunal competent to do so, has unequivocally announced its removal from our jurisprudence. Until then, the observations of the English law lords are most safely regarded as in the nature of premature funeral orations." Burroughs argues for the eradication of needless differences in terminology and substantive inconsistencies which exist between common law and equity. In examining the two bodies, he identifies three categories of English private law and examines the role which this coexistence plays in each. The first category he identifies is where there is a coherent division between common law and equity, and where the dual labels are useful. For example, in trust law, where the distinction between legal and beneficial interests serves a crucial role. The next category he describes is where the distinction is coherent but nothing is gained. Taking the example of pressure being brought to bear on a party to a contract, he queries what purpose is served by having both a common law doctrine of duress and an equitable doctrine of undue influence. The final category he identifies is that into which most civil law falls, where there is no coherence to the coexistence of common law and equity. Here, he attacks the different approaches which exist in many areas, including those with respect to illegal contracts and the limitation of actions. Ultimately, he stresses the need for a genuine fusion of the two bodies and the emergence of a principled system which combines elements of both.